And thank you for joining us today, whether that's from the US or from NZ. We're glad that you can make the time. Please do note that this session is recorded. My name is Rebecca. I'm the Engagement and Outreach Coordinator here at Fulbright, New Zealand. Like I said, please mute yourself during this call. You can leave your cameras on if you like, and you can unmute yourself at the end if there's any questions. There will be time for questions. You are welcome to pop any questions you have in the chat or the Q&A function, and we'll get to them after the meeting. So we'll let Robert go through with his presentation, and we'll just answer any questions at the end. Joining us today from Philadelphia is Robert Field, Professor of Law at the Thomas R. Klein School of Law and a Professor of Health Management and Policy at the Dornsife School of Public Health of Drexel University in Philadelphia. Robert was a Fulbright specialist at Auckland University of Technology in 2018. And at Auckland University of Technology, Robert assisted in developing a postgraduate major in non-communicable disease. And today he is kindly joining us for this month's Good Works webinar. And I'll hand over to you, Robert.
Okay, thank you. And hello to those in the United States and kia ora to those in New Zealand. As Rebecca said, I'm in Philadelphia. I teach at Drexel University, both at the law school and the public health school. So my interests bridge those two fields, basically health law, health policy, and bioethics. My research is largely on privacy issues related to new technologies, particularly those I'm going to talk about today, genomics and neurotechnology. I've also done a lot of work looking at the US healthcare system and looking at it in international perspective. It's a very bizarre system, and looking at the role of government programs, written 2 books about the US healthcare system. As Rebecca also said, I spent a wonderful 2 months at Auckland University of Technology in 2018, working on non-communicable diseases, particularly nutrition issues, and hope to return at some point. So my topic for today, as you know, is my work on privacy of new technologies and some of the particular challenges that genomics and neurotechnology present. I will share my screen and okay, can you see it?
We can see that.
Okay, and let me go to slideshow mode. And is that now visible as a full screen?
Yes. Yeah.
Okay.
Perfect.
Okay, technology works. So that is the topic, and that is who I am. And just briefly, this is Drexel University, my home institution. You can see on the left, it's a very urban campus right near downtown Philadelphia. And on the right, that is the law school where I teach and where I work. So to begin with the bottom line, the theme for the presentation. New technologies, database technologies, have led to miraculous applications in healthcare, in well-being, in many other ways. But that data can be dangerous, and let the data subject beware. You should know how the data could be used, what the risks are, and what the legal protections are and are not. Law and ethics have a long way to go to catch up. I think more in the United States than in some other countries, but it's changing so rapidly that it's very hard to get a policy grip on these areas and their risks. So this is my other theme. As you probably know, data is money. That's our new currency. It is the reason that companies are chasing it and spending a lot of resources trying to get you to be engaged with websites and services and provide your personal data. And a lot of people want to get their hands on that. And a quick overview of where the talk is going. First, I'll talk about the 2 technologies. the technologies themselves, their risks, and what I would call exceptionalism, how they are different from existing technologies, existing, for instance, medical data, and why they need special legal and policy treatment. I will focus on the privacy protections and data rights in the US with a focus on the special case of commercial direct-to-consumer data collection. That is, for instance, 23andMe and Ancestry, where your DNA is analyzed for a fee, but they get to keep your information. I will briefly talk about the contrast with privacy protections in the European Union and in New Zealand, which has a fairly data protection law, and then go over some of the new challenges for law and ethics as we move forward. So this is a kind of schematic on the evolution of data collection. If you look at the upper left, that's a certificate from the city of New York from the 1800s, and that's a vital record. And that was personal health data collection 150 years ago. Useful, but fairly primitive and clumsy to work with. We then went to newspapers, mass distribution newspapers, which could reveal information about an individual, and in some cases, personal information that threatened their privacy. I'll refer to that in a few slides. Credit cards, they've been around for decades. Every time you make a purchase, that's data for the credit card companies, and they can share that and they can use that to look at your spending patterns and to be part of the process of targeting ads. On the right is what we used to call a loyalty card at supermarkets here, where to get discounts, you would present the card, and then the card would tell the supermarket what you had bought, and so they could send you coupons and ads and direct you to specific products. Then we go to the internet age. At the bottom left, we have web searches, and we know that unless you're using DuckDuckGo, Google and the other search engines are keeping track of what sites you visit and how you link one site to another. Social media, which we know is incredibly important. Wearable devices, which are tracking you, keeping track of where you are, vital signs, blood pressure, maybe pulse, and then Alexa on the lower right, which hears what you want and maybe here's what you don't want it to know, because there are stories about how it's on all the time. And then we come to biometric information. We've been collecting clinical health information for decades, but the new technologies I'm going to talk about are different, more intrusive, and much more powerful. There is the voluntarily shared biometric information, the fitness apps, when you keep track of your running routes and your biking or your hiking, and then the health apps, in addition to the wearable devices. And then the next level of intrusion, genetics, brain function, and facial recognition, which is not necessarily voluntarily shared, and that adds another quantum leap in intrusiveness. So I'll begin talking about genetics. On the left, I'm sure you all recognize, is a model of a DNA molecule. In the middle is the base pairs, ATCG, which always go together, and that defines our genome and the way our cells do whatever function they're programmed to do. And on the right, you can see the printout of part of a gene. Genes generally have 17,000 to 20,000 base pairs, so this is a snippet of a gene. It's those 4 letters repeated again and again. What does that look like? Reminds me of computer code. 4 letters instead of 2 digits, 0 and 1, but it's very storable, it's very manipulable, and it's really comparable to keeping a computer data. So in other words, very easy to store and use. The reason we're talking about it to a large extent is the Human Genome Project, a project of the National Institutes of Health in the US during the decade of the 1990s, which endeavored to map the entire genome, 3 billion base pairs, and it mapped all of them. It didn't necessarily show what each of them did or what segments of base pairs represented a gene, but it showed where those base pairs were and therefore how we could disaggregate them and figure out what a gene was and what it did. And it's the fruits of that project which created the power of genomic analysis to predict our physiological state, our psychological state, our propensity to different diseases, and really all of our characteristics. So it's really been since 2003, about 22 or 3 years, that we've been seeing this dramatic increase in genetic information and the uses of it. A distinction I want to make at the start is between genetics and genomics. And I have to admit, sometimes I am not scrupulous about keeping them separate, but genetics is generally referring to a single gene, a single base pair. So on the left, you see the BRCA gene, the breast cancer gene on chromosome 17, and the base pairs there can make someone particularly susceptible to breast or ovarian cancer. On the right, you see a genomics study, which is genome-wide, looking at someone's entire genome, 23 chromosomes, 3 billion base pairs, which is a more powerful way of looking for correlations between patterns of base pairs and conditions and diseases. So it's the progression from genetics, single genes, to genomics, whole genomes, that has, again, enabled a plethora of discoveries and applications. What do we use them for? What kind of applications? I'm sure you're all familiar with ancestry tracing. Here, 23andMe, Ancestry are the big companies. You spit into a little tube, you send it to them, and they will give you an estimate of where your ancestors are from. Not always perfectly accurate, but people are fascinated by the chance to get at least a suggestion of where their biological roots are. In clinical care, we have seen the creation of tremendous medical advances. Cell and gene therapy. Gene therapy is actually inserting corrective genes into people to correct a deficit. Cell therapy is mostly for cancer, extracting usually immune cells, putting in new genes to give them new capabilities, and then transferring them into the patient. Pharmacogenomics, which allows doctors to tailor drugs to each person's particular genetic makeup. For cancer, often the genetic makeup of their tumor, and then something called precision medicine, I'll talk about in a second, and then personal enhancement, knowing what your physical constitution is and what kinds of susceptibilities you have, and maybe what potential abilities. Personalized medicine, also known as precision medicine, is where doctors can look at your genetic makeup and predict, based on that, what drugs will work. Again, used mostly for oncology, where you have a situation now where you have a drug that on average extends life for 6 months, but for some people it has no effect, and for some people it extends life for years. Wouldn't it be nice, before you go through the pain of chemotherapy, to know whether it's likely to work? Well, precision medicine is looking at your genes to predict whether or not it will work, and then give you the therapy that's likely to work with the minimum side effects. So in a lot of ways, miraculous. So we're getting something very important for this technology. We also see non-medical uses, law enforcement. There was a famous case in the US called the Golden State Killer about 10 years ago. Police in Sacramento, California solved a decades-old cold case of a rapist and murderer through a sample of the suspect's DNA that they put into a database, and were able to identify the person. Turned out it was a retired member of the police force. but they were able to identify him and convict him, and also proving innocence. In multiple cases, defendants are able to show that their genome does not match that of the suspects. And then, of course, marketing, where this is used, like all of this data, to target ads to you and what you're likely to want to buy. If you think of adding your DNA to that, we could look at whether you're likely to get heart disease, diabetes, Alzheimer's, whatever, and then make you aware of whatever products are relevant to those. So here's the big catch. Except for clinical databases, where the information is kept for you, for your treatment, the large databases, the commercial databases, the research databases, store the information anonymously. So you're pretty safe, or you think you're safe. This researcher, about 7 or 8 years ago, was able to identify a set of participants in a database based on their DNA and certain demographic characteristics. And here is the title of an article from 2018, identifying genomic data using long-range familial searches, looking at other relatives and using that data to de-anonymize people's genomes. The authors claim that they could identify relatives of the target subjects up to third cousins for individuals of European descent, which is the majority of US residents, identify relatives, therefore, who had never provided samples, probably don't even know who you are, you don't know who they are. And he felt that the potential would exist to basically identify any American of European descent. Now, this is not an easy technique, it's in development. You can't take any database and figure out who's who, but it shows that it's possible, and with refinements over time, there's a good chance that anonymous DNA databases will not remain anonymous. So I thought this chart was interesting. So who are these relatives that might be identified by you, or you might be identified by them? And you can see on the left, your close relatives, your parents, your siblings, grandparents. On the right, then you see the web of cousins, first cousins, second cousins, third cousins. So each of us has hundreds, maybe thousands of third cousins who you will never meet. And yet a sample of their DNA might be able to identify you, and therefore perhaps a propensity to a disease like diabetes or heart disease. What does it mean to find out things about distant relatives? Well, this chart looks specifically at schizophrenia, which has a genetic component, although it's not entirely determined by genetics. You can see at the bottom, identical twins, even with the same DNA, they only are about half as likely to develop schizophrenia if their identical twin has it. Nevertheless, there's a much greater chance than average. And then you can see fraternal twins, siblings, aunts, uncles. There's a greater chance of their having schizophrenia if they have a relative who has it than in the general population. Who would want to know this? Well, maybe an employer. Odds are you're not going to get schizophrenia if you're related to the patient, but there's more of a chance there than a random person. And maybe an insurance company would want to know if you're likely to incur healthcare costs or long-term care costs or some other losses for them. So what are the risks of disclosure? Discrimination, as I said, insurance, employment, perhaps housing, long-term care, financial services. A bank might not want to lend to someone who could become sick and disabled and not be able to repay the loan. Results are often misunderstood. Generally, they are probabilities. They don't say you will get this disease. They say you have a much greater chance than average. Many people, both patients and those using the data, don't understand that. And the math can get quite complex. Law enforcement could be biased based on a propensity, say, to a behavioral disorder. There might be an assumption that you're more likely to be guilty. Embarrassment, social stigma, if you have propensity to certain kinds of diseases, particularly behavioral conditions. Unwanted personal revelations. I'm sure we've all heard stories about people who discover their parents aren't who they thought they were, that either there was a relationship among their parents that had not been revealed, or there was a donor of sperm or eggs, or some other arrangement they didn't know about. And for many people, they'd rather leave the secret secret. Loss of control, the sense of genetic determinism. Is there a sense that you are your genes? And if your conditions appear, you will be defined more by your genetic propensity than who you are in relation to other people. Racial stereotyping is a big problem, dating back 100 years ago to the era of eugenics, where there was a belief that race determined a lot, incorrectly, but there's a tendency of people to generalize. The psychological stress of revelations or of discovering you might develop, say, early onset Alzheimer's, and significantly, a reluctance to seek care. If people are afraid that their genomes will result in any of these other risks, they may refuse to have their genome sequenced or avoid seeing healthcare practitioners. So there obviously are risks that go with the tremendous benefits. I thought this was interesting. Opinions on privacy in a number of different jurisdictions. As you can see in most of them, US, EU, China, India, Brazil, there's more concern with financial records. You can see the short-term effects of identity theft and hacking into someone's bank account or brokerage account. Health is a concern, but less so. And interestingly, much less so in China and India than in the US and EU, in the Western countries. So people are concerned about privacy, more so as time goes on, but not as concerned as you might assume. And then what does this mean for a physician? The survey of doctors of patients with Parkinson's disease. Question, would they order genetic tests to try to determine the kind of Parkinson's disease, or to determine whether a condition actually is Parkinson's disease? A lot of reasons why physicians are reluctant to order the tests. Number one, in the US, is we don't have national health insurance, so the patient's insurance might not pay. But if you look down towards the bottom, 40% were concerned that a test might affect a patient's employability or insurability. Without privacy protections, the doctors themselves were concerned about that. And then at the bottom, 40% worried, or 46% worried about the implications for other family members who might be stigmatized by knowing this information. So, is genetic information exceptional? Are these data special? I would say absolutely yes. There's a lot of controversy about that in the bioethics community, but I would say these are immutable until we have CRISPR genome editing on a wide scale, which isn't going to happen for decades at least. You have the DNA you're born with. So unlike a blood test, you don't have the cholesterol you were born with, the blood sugar, the blood pressure. You will always have that genome. It's highly personal. The more we learn about genetics, the more we can say things about each person and their physical and psychological makeup. They're identifiable. As I showed you, that study was able to identify many people with anonymous genomes in a research database. And should the anonymity be breached, your DNA is unique to you. So you will always be identifiable by your DNA. And then the ability to identify relatives. Um, Again, your cholesterol level doesn't identify who your cousin is, but your genome does. Therefore, I would say special legal treatment and special ethical considerations are appropriate. So neurotechnology and brain data. On the left, you see someone with looks like a bathing cap and electrodes on it, and the wires are going to a computer, and you can see on the right that's an EEG readout, and they're saying they can show the way that the person reacts to different stimuli, if they're concentrating, if they're trying to memorize something, if they're seeing a stimulus that's either favorable or aversive. And that EEG readout, like the sequence of base pairs, is something that can be easily stored indefinitely. So if you're interested, if you're browsing online, here's one company, Emotive, sells these devices that you put around your head or you wear, with regard to the one on the right, and it will send those impulses to the computer. These are called BCIs, brain-computer interfaces. How accurate they are may be open to question, but it's pretty easy to get this and to then have an EEG readout that says things about your focus and your concentration. What it also does is create the data that Motive or whatever company is the provider is going to want to have and sell. How can this be used clinically? Even these external non-invasive EEGs can say things, help to diagnose Alzheimer's, Parkinson's, brain damage, not as perfectly as other tests, but can give an indication of whether one of those conditions is likely. Wellness in terms of helping people to focus on well-being, relaxation, focus, education, helping you to learn and study, use in a workplace in terms of training, military and national security to help the person focus and pay attention. You certainly want that with, say, pilots and truck drivers, law enforcement. These could potentially replace lie detector tests, sports, helping with the psychological aspects of training, and increasingly games, consumer devices. So you don't use a joystick, you don't use a mouse, you just think what you're going to do to get to the next level of the game. What are the risks? Similar to genomics, embarrassment. If your responses show things that you'd rather not be known, unwanted personal revelations, asking people questions, and again, it can be sort of like a super lie detector test, seeing how they react, or giving them stimuli like corporate logos or political messages and seeing how they react. This could, of course, lead to discrimination, intrusive law enforcement, and the risk of cognitive manipulation, actually training someone to think certain ways. So let me show you an experiment that was done at the University of Washington about 15 years ago. They took a computer game called Flappy Whale. They had the users wear one of those caps with the electrodes on it. You try to get a whale through a maze, and the game becomes increasingly difficult. As it becomes difficult, they interspersed for milliseconds so that they were completely subliminal. Logos for fast food restaurants and for cars to see how people responded and to kind of condition them. Or they felt there was a potential for conditioning them based on those fleeting images. This could certainly be used for directed marketing It could also reveal potentially financial information, religious beliefs, politics, medical conditions, prejudices. Um, they stopped the experiment and promised never to do it again, but that potential is out there for a pretty scary application. So are these data exceptional? Again, I would say absolutely yes. The intrusiveness, the intimate nature of the details is unique. It's identifiable. They're finding out things about your brain. You could identify others, people that you know, and there's this potential for behavioral manipulation. So all of this data is aggregated in many different ways. When your doctor enters your information in a electronic record, that's kept by the hospital or the health system. It's often used for research. It's often sent to the computer company, and that, of course, is highly identifiable. The commercial testing companies, it's used for research. Insurance companies keep your health data in connection with claims. Drug companies want this data in terms of drug development, and employers keep data, at least in the United States, from physical exams, from corporate wellness programs, from disability claims, and from lawsuits from the plaintiffs that are suing them, as well as compilations from your credit card, your search engine use, your social media, and government databases. We have a system in the US called CODIS, which keeps track of DNA of criminal suspects, often both those who have been convicted and those who are acquitted, immigration, benefits programs. When you apply for a program like in the United States, a health program, Medicare or Medicaid, your information is kept, and then the apps, the health and wellness apps. So there are a lot of ways this information is useful, is stored, and has a lot of purposes, including monetary. So how do we recognize privacy? The first reference in the US of a right to privacy was 1890, article in the Harvard Law Review. Warren and Brandeis. Brandeis went on to become a Supreme Court justice. They were talking about newspaper photos. So look at the words I've highlighted in yellow: instantaneous photographs, which was new at the time, and the newspaper enterprise have invaded the sacred precincts of private and commercial life. And the prediction was, what is whispered in the closet shall be proclaimed from the housetops. So in 1890, newspaper photos, this new technology, were a privacy concern that these legal scholars felt deserved special recognition. There are a couple of human rights declarations. Universal Declaration of Human Rights from 1948. No one should be subjected to arbitrary interference with privacy, family, home. That right was incorporated into other human rights covenants, but there's been haphazard evolution since then. So there really is not a universal global agreement on what privacy rights are, what can and cannot be done. And as a result, there's tremendous variation between countries. Privacy can be seen as a matter of autonomy, informational privacy, what's known about you, but also decisional privacy, your right to make decisions, particularly about your healthcare and your body. And with regard to neurotechnology, that comes into question. And we now add AI and machine learning to ways to manipulate and milk the data for more information, biometric measures, facial recognition, and social media. So technology is rapidly changing the playing field. It's certainly not newspaper photographs the way it was in 1890. Other question is, who owns the data? People can learn about it, but who can use it? And who has the right to sell it, which is perhaps the most important issue in how it gets used. Couple of stories that are well known in the United States, at least in genetic circles, that I'll just mention here because they are so reflective of the kinds of issues that arise. Henrietta Lacks was a woman with 5 children in Baltimore who developed cervical cancer and was treated at Johns Hopkins University in 1951. Tissue was removed as part of her surgery. She did end up passing away, but the hospital kept her tissues and her cells and discovered that they were essentially immortal. They did not die, and for some reason, I don't think they still understand it. These were special cells. They called them the HeLa cells, and they have been used over the last 70 years for things like developing the polio and HPV vaccines, in vitro fertilization, and a host of other miraculous discoveries. Today, researchers, drug companies can purchase them for a few $100s a vial, and they are crucial for a lot of research. The family never knew that her cells were the basis for much medical innovation. In 2011, a book was published, The Immortal Life of Henrietta Lacks, explaining this. The family had had no idea. Family recently achieved a settlement with a scientific company which had used the cells. Johns Hopkins and the NIH issued a public policy and new guidelines for use of the cells. You can see the book on the upper right, promoted educational efforts to tell the story. But what's missing here, with the exception of that one lawsuit, no money. The Havasupai Indian tribe lives in the Grand Canyon. You can see a picture of their settlement in the upper right. They've been there for centuries. Researchers from Arizona State University asked for genetic samples first to study diabetes, and then they came back to do follow-up research on behavioral disorders. The researchers were really interested in schizophrenia. 100 tribal members agreed to the use of their data, but most hadn't even completed high school, so it's not clear they knew what they were doing. They saw no genetic link, but kept the samples to study other conditions like alcoholism, did not get additional consents. They did discover something about tribal origins based on migration patterns and the way the ancestors had migrated down from Alaska throughout North America. But that upset their religious traditions. And that really upset the tribal members more than anything. 41 of them sued, the university settled. They did get some money out of it, but they had never been warned about what they were getting into. Few cases in the US on who owns data. 1990, Moore versus the University of California, a physician treated a patient for leukemia, extracted cells and his spleen, got a $3 billion patent, never even told the patient about it. When the patient found out, he sued for a share of $3 billion. Court said, no, you, the patient, have no rights to it. 2003, Greenberg versus Miami Children's Hospital, parents of children with a rare disorder, Canavan's disease, donated blood and tissues. The doctor went on to identify the gene involved, obtained a patent, family sued but was not entitled to any of it. Washington University versus Catalona, Dr. Catalona collected samples from prostate cancer patients. They wanted the cells to stay with him when he wanted to leave for another university. Court said no, they stayed with the original institution. In other words, the rights of the patients or the research subjects are very limited. It's the doctor, the researcher, or the organization obtaining the information that has those rights. The AMA, American Medical Association Code of Ethics, is kind of wishy-washy. It's, of course, a suggested code. It's not law, but it says that a doctor should obtain informed consent and tell a patient of a possible commercial interest. They may share profits with the patients. How often does that happen? I would wager 0. They have to avoid a conflict of interest and advise alternative treatments that do not involve profit potential. But again, how often is that actually going to happen? So that gives a sense of who can use the data, who can see the data. In the US, it's different laws for different kinds of data, for medical, for research, and for commercial. For medical, we have the HIPAA law, which says that patient information cannot be disclosed, but it only applies to what's called covered entities, hospitals, doctors, payers, and it can be disclosed without consent for treatment, for payment, in the public interest, if it's de-identified for research. In other words, there are a lot of gaps. The common rule is a regulation of 19 federal agencies that requires institutional review boards review research protocols for risks, including risks to privacy. There is an exception for de-identified data, but as we have seen, even genomics data can be re-identified, at least in some situations. In 2018, data with identifiable private information may be stored indefinitely with patient consent, can be used for future research, and the subject need not even be told what the future research involves. So again, big gaps in the protection of the private data. And then several states have their own legislation. California and Washington, for example, have very strong laws, but they only apply to state residents. There are some protections against discrimination based on health status. The Americans with Disabilities Act says that employers and public services may not discriminate based on a disability, but a genetic predisposition to a condition is not considered a disability until that condition manifests itself. So you may be prone to diabetes, but until you get diabetes, you're not protected. The Genetic Information Non-Discrimination Act, passed about 15 years ago, prohibits discrimination based on genetic data, but only in employment or health insurance. Does not apply to other kinds of insurance, education, housing, mortgage lending. And the irony is that about 5 years later, the Affordable Care Act prohibited discrimination in health insurance. So that provision ended up being redundant. So my interest that I want to spend a couple of slides on, the direct consumer testing. You've probably all seen ads for 23andMe and other companies that will help you understand your ancestry, health issues, by simply spitting in a tube and sending them $99. Lots of companies, a field that is growing rapidly, largely because the cost of genome sequencing has come down. In 2000, as the Human Genome Project was ending, it was about $100 million to sequence one person's genome. It is now a couple of $100. That's why these companies can do this to scale and get thousands, millions of people's genomes and give them their findings. It's $99 to get the results, but that data is where the real value is. You can see the way the field has grown dramatically in the last few years. On the neurotech side, you can see the way that has grown. 2022, $2 billion, and the predictions are that by 2030, the 2030s, it will be close to $10 billion. Interestingly, how is this brain data used? About 10% is used for gaming. Healthcare, though, is an increasingly important application. Is the data vulnerable? Here are a few headlines. Time magazine, a major data breach, a hack at 23andMe, almost 7 million users' information, including some health data in addition to the genomic data. That's one of the reasons that the company started losing customers and is now bankrupt. In 2023, 8 billion records reached, health records in different data hacks. And then on the right, 23andMe declared bankruptcy a couple of months ago. What's its most important asset? Its database. And that could be purchased by a data broker, an insurance company, who knows who. And all that information now is in the hands of another company that you never expected to do business with. What are your protections in the US? Well, it's not health data, so HIPAA doesn't apply. It's not federally funded research, so IRB review and the common rule does not apply. Some state laws apply, but only for their residents. The only real protection is the privacy policy and the terms of service. Those are voluntary with the company. They vary, they're changeable, and as we're seeing with 23andMe, little protection with corporate changes. On the right, I found this interesting. If you're starting a company to collect personal data, you can download a privacy policy. You just put the name of your company in, and voila, you have a privacy policy. I think that gets a sense of how serious they are. A survey about 5 years ago of 90 genetics companies of their privacy policies found, for example, 39% had no privacy policies on their websites, 30% were vague, all permitted changes without notification. So you could feel you're safe when you send them your samples. That does not mean you're safe years down the road. About half say they can keep the data indefinitely. So just an idea of what some of these policies say. Ancestry.com says that if you interact with social media through their services, they will collect those interactions and merge the data. Third-party partners can access the data, and they will use that for targeting ads. Emotive, a neurotech company, says that they will share data with third parties, and third parties will share with them. And look at the bottom, significantly, we reserve the right to modify this policy at any time. So again, you may feel comfortable when you put the headset on, but that doesn't mean you're protected even 30 days from now. Quickly, by comparison, the GDPR, the General Data Protection Regulation of the EU, is comprehensive. It was considered a revolution in data protection, applies to all companies and all kinds of data. It gives you the right to have your data erased, to be forgotten, to receive data in a commonly used format if you want to transfer it to another company, and to not be subject to an adverse decision based solely on the data and AI. Companies must use reasonable measures and notification of breaches. Penalties can be up to 4% of annual revenue. If this is Google, that's billions of dollars. However, enforcement has been uneven, and it is difficult to enforce a complex law like this, especially when you're dealing with 28 different countries. And then New Zealand, the Data Privacy Act of 2000 updated a law from 1993. It again applies to all personal data that is not anonymized, covers all public and private entities, but monetary penalties are only up to $10,000, and there's a limited private right of action. New Zealand has a privacy commissioner who enforces it, but citizens have to rely on that office as the primary means of enforcement. The data controller must ensure the information is protected. kind of vague language. However, you can access your information, request corrections, and lodge complaints. But data disclosure is permitted in a number of circumstances. So again, a more comprehensive law than the US has, but still leaving gaps. So imagine the next step. We've got genomics, we've got brain data, we've got facial recognition, browsing history, social media history. What could a foreign government or company do with that? What's left of privacy? Legally, we need more comprehensive laws that are international, are nationally comprehensive, which is an issue in the United States, and are applicable globally because data moves around the world at the speed of light, while not discouraging participation in databases and keeping the information flowing. I'm going to end talking about some data ethical challenges, which could talk about forever, but I find them fascinating. What's voluntary data sharing? When you use a connected device, is it voluntary? If you haven't read the terms of service and your health indicators, your running speed, your walking distance is sent to a company, when you use social media, you pretty much have to, in some instances, to be part of a community, data scraping by data brokers, putting this all together. What is voluntary? And then more broadly, what's personal responsibility? What's criminal guilt when your genes and your brain function are responsible, or we can see how they're related to what you do? It raises new issues of personal autonomy and personal identity, as well as personal decision making. Are we our genes? Are we our brains? Questions that we've been looking at for centuries, but take on new meaning today. And then finally, with regard to cognitive manipulation, will our thoughts still be private? Could they be manipulated? And how are we going to distinguish which thoughts are ours and which were implanted through technology? So what's the challenge ahead? The balance. We want innovation. We want scientific advance. We want personalized medicine, pharmacogenetics, and all of these life-saving technologies, but we need to protect subjects. We need to protect relatives who don't even know their data is accessible, and we need public confidence. So thank you, and I'm happy to answer any questions.
Thank you so much, Robert. Just while we wait for people to put any questions in the chat, or you could unmute yourself if anyone has any questions. Yeah, just wanted to let our attendees know if anyone's interested in applying for a Fulbright scholarship, there's information about this on our website. The NZ Scholar Awards close on the 1st of October annually, and our Fulbright NZ Scholar Awards are for New Zealand academics, artists, or professionals to lecture and or conduct research at US institutions. So you can find information about that on our website, or feel free to reach out to us if you have any questions. And yeah, we'll just wait and see if anyone's got any questions about today's webinar. Yeah, thank you so much, Robert. That was super interesting.
Questions from either continent?
Yeah, nothing's come through yet, but yeah, we'll just wait a bit. Oh, I think I see something in the Q&A box. Oh yeah, great. 2 just came through. So our first question is, in the UK, the government is giving US company Palantir access to the patient database. Has it been given / bought access to US genomic data?
I'm sorry, has the US government or has the UK government provided the access?
I'm not sure. So the question just says, in the UK, the government is giving US company Palantir access to patient database. Andrew, maybe you could expand on that a little bit on that question, if you like.
Sure, thank you, and thank you, Professor Field. The UK NHS National Health Service obviously holds huge amounts of personal medical data, and there have been increasing projects to digitise health records so that they can be transmitted and shared more easily, obviously to help medical care be provided in a timely manner. However, Palantir, Peter Thiel's company, has been seeking access to this to help sell services to the NHS. And my understanding is that they have now been given access to some of this data. I wondered if Palantir was active in seeking patient information or genomic information in the United States.
Yeah, not that I'm aware of. It's possible it's happened and I'm not aware of it. The thing about the UK that's so tempting is you have everyone in the country in the same system. In the US, we have a lot of different electronic health records databases and genomic databases. So we don't have any one compilation that's as comprehensive. And the National Health Service has been doing some great research since they have this unique opportunity to collect all that data. But I'm not aware that company or others have tried to do the same thing in the US.
Okay, thank you.
We've got a few other questions. I'll just pop to the one in the meeting chat from Lewis. Do existing privacy protections, where they exist, control the passage of information to more permissive jurisdictions?
They would. Well, with regard to the direct-to-consumer data, yes. You really have no rights for most of these companies as to what happens to the data. So, for instance, 23andMe went bankrupt, and creditors basically own its assets, and there's litigation ongoing now as to who can have the database. There's really nothing in their terms of service that would prevent it from going to a laxer either state or national jurisdiction. Remember, all of those private terms of service can be changed, usually with 30 days notice. So even if they did prohibit that, that could be changed.
Robert, all right, Patricia's question. When multiple companies integrate collected data and harm to an individual arises from a third party's actions involving that combined data, do current EU and US regulations hold all involved companies jointly responsible, or is liability limited to the initial data collector?
I think I showed one of those screenshots of a privacy policy explicitly said that the company assumes no liability for any misuse of the data. It would, I think in the EU, it would be the data collector and the data controller. So whoever gets control of that data. In the US, it would depend what kind of data. If it's clinical data, it would be the HIPAA law. If it's research data, it would be the institutional review boards. And if it's commercially collected data, it would really just be those terms of service, which are so changeable.
All right, thank you. Christopher is asking, do you think decentralization of data storage could help keep this data safe and in the control of subjects, e.g. the SOLID or SOLID web standards being led by Sir Tim Berners-Lee?
Mm-hmm. In the US, it pretty much is disjointed. As I showed, the big companies, 23andMe and Ancestry, each have about 15 to 20 million genomes, and they are separate. And then there are research databases. So it's already pretty diffuse. Two issues. One is you want to be able to link them for the most powerful research applications. So the more people you have in the database, the more power you have to find genes. For instance, there may be rare genes out there that confer, say, immunity to Alzheimer's disease. Maybe you see them in 1 out of every million people. Well, you would want to combine those databases to increase your chance of finding that gene. So there's important reasons to link them. I think having them in separate locations, I'm not sure that would really help. It's the same laws would apply to them, and the same abuses are still possible by the different data controllers working together. Although, I mean, it's an intriguing idea.
Right. Okay. Thank you. I'll just see if there's any more questions. I can't see any in the Q&A, and I don't see any in the chat. If anyone has anything else they want to ask Robert, just pop it in either the meeting chat or the Q&A.
Well, I guess it's lunchtime in New Zealand.
Yes.
Dinner time in the US.
Yep. So we're heading into lunchtime. Margie has asked, can we get a copy of the slides, please? Is that something you would want to share?
That is fine with me. If you use them, I'd like to be them to be attributed to me. You have a set of the slides that I sent yesterday, Rebecca. I made a few last-minute changes, so I will resend them to you as a PDF. So I'd appreciate it if you share the PDF version when I send it.
All right. If anyone would like a copy of the slides, reach out to engagement@fulbright.org and I will send them to you. And do please credit Professor Robert Field with any of those. And yes, so the recording will be uploaded on our YouTube channel in a couple of days. Well, with Easter, probably sometime next week or the week after when we get around to it. So that will be accessible on the Fulbright YouTube channel as well. And we'll share that on our website. So on our website under events where this webinar is listed, you'll then find the link to the YouTube video. And yeah, looks like that's all of the questions. Thank you everyone for joining. Keep an eye out for further of our Good Works webinars. They will be announced on our website and our social media. There'll be a Facebook event for any upcoming webinars. They're all open to the public. We'd love to see you there. And yes, thank you again to Robert. That was super interesting.
My pleasure.
All right. Thank you, everyone. Mā te wā.